Good day, everyone. I am Harvey Pineda, and for the finals for CPE Law, I will be discussing the Supreme Court case entitled Christian Catas E. Cavias versus People of the Philippines, GR number 247348, November 16, 2021. This case is important in today's digital era because it involves child pornography committed through online messaging, the constitutional right to privacy, and the state's duty to protect minors from sexual exploitation. In this reflection video, I will discuss the following. First, what the case is all about. Second, the facts of the case. Third, the issues involved. And fourth, the ruling of the Supreme Court. And lastly, my takeaways of learnings from this case. So, what's the case is all about? This case is about online sexual exploitation of a minor. It involves a 24-year-old man whose name is Christian Cadajas, who used Facebook Messenger to induce a 14-year-old girl to send him sexually explicit photographs of her private parts. This case also examines whether inducing minor to send nude photos to private online communication already constitute child pornography under the Philippine law. Even if the images were not sold, distributed, or publicly shared, it also addresses whether such private conversations, specifically online conversations, are protected by the right to privacy, and whether the accused can avoid a criminal liability by claiming that he and the minor were in a romantic relationship, also known as the sweetheart defense. Overall, this case clarifies how child protection laws and cybercrime laws apply to acts committed through digital platforms and social media. Next, we move to facts of the case. The accused, Christian Cadajas, was 24 years old at the time of the incident. He met the victim, referred to as AAA, who was only 14 years old, at the canteen where he worked. Later, AAA added the accused on Facebook Messenger, and they began exchanging conversations. Over time, the accused courted AAA and they became sweethearts. Despite their 10-year age gap, in June 2016, AAA's mother discovered their relationship after reading Facebook messages on her daughter's account. She strongly disapproved and warned the accused to stay away from her daughter because AAA was still a minor. Despite this warning, the accused continued communicating with AAA. In November 2016, AAA's mother once again accessed her daughter's Facebook Messenger account and discovered disturbing conversations. In these messages, the accused was persistent, instructing AAA to undress, remove her underwear, spread her legs, and send nude photos of her breasts and vagina. Due to the accused's continuous persuasion and pressure, AAA eventually complied and sent the explicit photos. These conversations and photos were retrieved by AAA's mother and later used as evidence. As a result, two criminal cases were filed against the accused. First, a case of violation of Section 10A of Republic Act number 7610, or the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. Second, a case for child pornography under Section 4C2 of Republic Act number 10175, or the Cybercrime Prevention Act. In relation to Republic Act number 9775, or the Anti-Child Pornography Act. After the trial, the regional trial court acquitted the accused of the RA 7610 charge, but convicted him of child pornography. The Court of Appeals affirmed that the conviction and the case was elevated to the Supreme Court. And next, issues of the case. The Supreme Court addressed several issues which may be summarized into two main legal questions. The first issue is whether the accused's constitutional right to privacy was violated. The accused argued that the Facebook Messenger conversations and photos used as evidence were obtained without his consent and should be excluded under the doctrine of the fruit of the poisonous tree. The second issue is whether the accused acts constituted child pornography. Specifically, the court had to determine whether inducing a minor to send sexually explicit images through private online messaging already constitute child pornography. Even if there's no intent to sell or distribute the images, and even if the accused claimed that the acts were done within a romantic relationship. Next, ruling of the Supreme Court. The Supreme Court denied the petition and affirmed the conviction of the accused. On the rights to privacy, the court ruled that there was no violation of the accused's right to privacy. The Supreme Court explained that the Bill of Rights protects individuals against government intrusions, not against actions of private individuals. In this case, the evidence was obtained by AAA's mother, a private individual, and not by any government agent. Furthermore, the accused voluntarily gave his Facebook Messenger password to the minor. By doing so, he limited his reasonable expectation of privacy. A person cannot claim privacy over information that he has voluntarily allowed another person to access. Thus, the Facebook messages and photos were admissible in evidence. On child pornography, the Supreme Court ruled that all the elements of child pornography were present. First, the victim was a minor, being only 14 years old at the time. Second, the accused induced and coerced the minor to create sexually explicit images through persistent messages and instructions. Third, the acts involved the lascivious exhibition of the breast and vagina, which clearly falls under the definition of explicit sexual activity under the Anti-Child Pornography Act. Fourth, the acts were committed through a computer system, since a mobile phone qualifies as a computer system under the Cybercrime Prevention Act. The court emphasized that intent to sell, distribute, or publish images is not required. The mere act of inducing a child to create sexually explicit material already constitutes child pornography. On the sweetheart defense, the Supreme Court rejected the sweetheart defense. It ruled that consent is immaterial when the victim is a minor. A child cannot give valid consent to acts that exploit or endanger her, even if she appears willing or claims to be in a romantic relationship. The court stressed that minors are vulnerable to manipulation and coercion, especially when dealing with older individuals who have emotional and psychological influence over them. The penalty imposed to the accused was he was sentenced to 14 years, 8 months, and 1 day as minimum, 18 years and 3 months as maximum, in order to pay a fine of 1 million pesos. So, what are my takeaways and learnings from this case? So, this case taught me several important lessons. First, the internet is not a law-free space. Acts committed online, even through private messages, can result in serious criminal liability. Second, children are given special protection under the law. Romantic relationship, consent, or mutual affection cannot justify acts that sexually exploit minors. Third, the right to privacy is not absolute. when a person voluntarily shares access to private information, especially when such information involves criminal conduct, privacy protections may be limited. Fourth, this case reinforced the role of the state as parents padre or the protector of children. The government has a duty to intervene when minors are exposed to abuse, exploitation, or manipulation. Lastly, this case reminds us that digital responsibility is legal responsibility. What we do and say online can have serious legal consequences, particularly when vulnerable individuals are involved.